State Employees Credit Union, docket number 12020B. Present for the Banking Division of the Department of Financial Regulation, attorneys Christina Rulo and Clifford Peterson. For the Vermont State Employees Credit Union, which I'll probably just keep referring to as the credit union.
That's fine.
Okay. We have Attorney Jacqueline Hughes, and you told me your name and I didn't.
Danberg.
Sorry. I guess well, first, I'd like to start off by asking you each how you'd like to proceed. This is a pre-hearing conference, but what do you think would be the most effective way of getting these issues disposed of?
I think this is essentially a housekeeping session,
yeah,
setting up procedures and that kind of thing. One thing I would like to ask you right off the top is how you want papers filed, by email, by hard copy, as PDFs, by whatever's convenient.
I think for me, by email, PDF, so there'd be no issue. You can email them to me and, of course, to the clerk.
Right, to the clerk for filing. And if that's okay.
That works fine.
Okay.
Good. That's taken care of. That's best for us as well. The rest of what I have here is scheduling. Attorney Hughes and I have just been talking about scheduling. We don't agree on everything, but we agree on some things. And what we have got is a proposed scheduling order for your consideration. And just briefly,
and this is the state's proposed schedule.
Understood. Understood. Yeah.
Okay.
Yeah. There are some disagreements, and you'll notice some dates are blank. We
Yeah.
agree on dates, and there's another issue here too. It basically, you order us to get together and stipulate to as much as we can stipulate to.
That was going to be my first question as to what facts are in dispute.
We can try to narrow that. This is certainly it's my object to get as much of this by stipulation as we can, cussed on paper later.
Yeah.
Then Attorney Hughes has said that after that stipulation, which we all agree can be scheduled to come to you on September 21, they'll just need 7 days to revise their existing memorandum of law to conform to any reduction of the issues or any focusing of the issues that's happened.
If necessary.
If necessary. Or any new ideas they come up with, or new case law that might come out. Then the department, which hasn't filed a memorandum of law yet, will have until blank to file. We would like 3 weeks, which would be to October 19. Attorney Hughes thinks that's too long.
You have had their rather extensive memorandum of law for quite a while. So
right.
Why do you need 3 weeks?
Because I don't know what new they're going to be doing.
Sure.
You know, that memorandum of law was written for a different purpose, for a declaratory ruling.
Yeah.
And by the time we stipulate to facts and reduce the issues, and anybody who's ever filed a brief knows that 2 weeks later there's another idea that occurs to them. I don't know what's going to be in their revised memorandum, and 3 weeks does not seem unreasonable.
Well, frankly, I think they've had a fair amount of time. The documents that started this proceeding do include a legal analysis and their conclusions on what the law is. They've had it since our response, where we adopted the facts, the law, and the exhibits from our petition for declaratory relief. They've had that since June 18th at 8:09 in the morning.
I wasn't here at 8:09 in the morning.
I was. And so I think for the core issues that we've already raised, 3 weeks is way too long. I mean, we're going to enter negotiations on the findings of fact and perhaps narrowing the legal issues. In good faith, we'll work very hard towards that. And I don't think we'll need a lot of time to respond once that is, once our stipulation happens, because we'll be working on it as we reach agreement with the state. I think 3 weeks is too long, especially because we would like to see the hearing on this scheduled for October 19th. So we would propose giving the state an additional 5 days beyond what we're having. So in other words, we have 7 days, they get 12, and then we would propose that the hearing be conducted on October 19th.
It seems to me that if the issues remain the same, that the legal issues that you've raised and the factual issues you raised remain the same, then it seems as though 3 weeks is more than enough. What I would ask you to consider is, if indeed there are new factual issues and new legal issues raised, then we keep it, we allow the state until the 19th. But it seems to me that unless there's a change in your theory, and there's some facts which I can't imagine which come up, but they may. Unless that happens, it seems to me that the state should be able to respond within 10 days following your response. And so the way I would propose to do it is the state, after they get your papers, the state says, these are the new issues, we want till the 19th. I make a decision without talking to you. You know, you can respond if you want, but I just make a quick decision based on the papers you filed and your response as to whether or not it goes to the 19th. That runs into a problem for you as far as the hearing date, but because it's conceivable that on the 19th they'll be filing their papers if there are new issues.
Mm-hmm.
So,
Well, we could have a contingency.
That's what I was going to suggest.
That it'd be the 26th,
Yes.
if they flag, new issues for you that we've raised.
Yeah, and it seems that it seems only fair that if you do raise something new, that they have that extra time. If you don't raise something new, then 10 days should be enough, it seems to me. That's 10 days from after they get your papers.
Yeah.
Yeah.
10 days from
Yeah,
service
yeah,
on us, which
yeah.
presumably would be instantaneous with filing, since it'll be by email and PDF. 10 business days or 10 calendar days?
I've forgotten how the rule works. I think it should be
If
10
it's
days.
Calendar, if it's,
10
Yeah.
calendar, then you don't count the weekends.
Yeah.
So if you just say 10 days, you don't count weekends. If it's 11 days, we have to work weekends. I was just thinking of the dates, I don't know what day of the week.
Yeah,
Well, the
can you
28th
look
is
it
a
up on
Friday.
your calendar?
20th is a Friday, October 10th is a Wednesday.
So why don't we
So
say-
if you said 10 days, that would be October 8th, which is a Monday.
Why don't we say the Wednesday?
Okay.
Okay.
October 10th.
October 10.
You have to have your papers in unless there's,
Okay.
and then you just, if you think there are new issues, you send it to me, and I decide right there whether you're right or whether I think you're right.
Understood.
Okay.
Come back to paragraph 4 in a second. As to when to schedule the merits hearing, not knowing your calendar and your availability, that's just let
I should, because at the Champlain, I'm working there, and occasionally I have jobs with the Board of Medical Practice, but the times for sure, Wednesday, all day.
You're free on Wednesdays?
Yeah, with one exception, that's the first Wednesday of the month. If we can work, we can work.
Leave it blank, and
Yeah,
if you want to.
yeah, and I'll send maybe, probably Wednesday's the best day,
Yeah.
and I can work around it. I can also do Friday afternoons, Monday from 11.
We're at your disposal.
11 till dark, you know.
That,
So does that give you some idea?
whatever day works for
Yeah.
you, basically. And perhaps, given the ambiguity about October 10 versus October 19, maybe we should just leave that for now.
Well, I think it'd be,
Or set it for October, Wednesday, 17th, October 24th is a Wednesday.
that going to work as a tentative for everyone?
Yes, we will make it work.
Paragraph 4, and Attorney Hughes and I have already talked about talking, would be you ordering us to engage in good faith settlement discussions. The only issue there, I think, well, since administrative procedure doesn't bring in the confidentiality provisions of 408, the order does so. And shall otherwise be confidential, non-discoverable, the usual drill on.
I think that makes good sense.
Yeah.
Well, I haven't been heard on that.
Yeah,
Sorry.
and if I can just finish, we disagree on the last clause, that what happens in settlement shall not be disclosed by the parties to non-parties. There's been a great deal of press on this. None of it originated from this department, very little of it, and that extraordinarily neutral from this department. And I think it would be detrimental to settlement discussions if settlement discussions wind up getting publicized.
All right.
So we agree with paragraph 4, when it gets to the word matter, we'd like to see a period put right there. So in other words, paragraph 4 would read, the parties are to engage in good faith discussions toward the resolution of this matter, period. This is a First Amendment case. We view this paragraph 4 as a gag order. So it's a gag order on top of the proposed gag order they've already given our client. So I think that counsel for the state, counsel for VSECU can work out how negotiations will be structured. I don't believe we need the hearing officer to issue at the outset what amounts to a gag order.
I guess I misunderstood. I thought that the basic issue was whether or not your settlement discussions were going to remain confidential.
And Rule 408 goes to liability and damages. We don't have liability and damages involved in this. That rule is designed for a very specific purpose, and this is not that purpose. I think counsel should be able to engage in conversations. We can talk first about what the ground rules will be. But we are very concerned that there is evidence that we have not had access to yet, that if it comes up in these negotiations, that somehow the state's going to argue it's off limits. And
no, that's, you would not argue that, would you? I mean, certainly if there's...
I'm sorry.
Yeah. I mean, if there's evidence that it turns out to be relevant, and you wouldn't use the settlement discussions to say that can't be admissible later on.
Absolutely not. Evidence is evidence.
Yeah.
That's straightforward.
Yeah.
What I am concerned with, and I have to tell you I've been burned on this, is stuff getting out that, well, the department said a week ago that they're willing to do this, and now in front of the hearing officer they suddenly say, that kind of thing just trashes any settlement discussion. You can't work.
You're both so experienced, it seemed like you know that that's not going to work. If you want operating in good faith, that's not going to get you to the
I agree.
good faith resolution.
And frankly, Mr. Hearing Officer, I think we don't need to have you say that to us. So that's my objection to this paragraph. If we can't even get to the what is fair game in a settlement discussion or what is off limits for further discussion outside the context of a settlement negotiation, I don't think we're going to resolve this.
That does sound... so your proposal is you agree among yourselves as to what will be disclosed?
Absolutely.
Okay. And then, of course, you have veto power.
Right. And I suppose if there's a disagreement as to how settlement discussions are to proceed, we may have to come back together.
And at that point, we might as well have a hearing. I mean, if we can't get to the, if we can't agree to how we're going to...
If we can't agree to be confidential when talking, then we're in real trouble. I do, would we say there's no liability, actually, what, $15,000 or something, account on the credit union side, so there is that. So I think Rule 408 ought to be imported in here. we can't do that privately. Only you can bring Rule 408 in.
But the 408 is designed to keep from the jury discussions about where the deep pockets are, and if there's an admission of liability and the settlement discussions fall apart, the jury doesn't get to hear that I said, yes, my client, ran you over. That's what 408 is about. And, whether it applies in a hearing officer context, I would think any factual discussions that we have should be fair game for this hearing.
Well, then it doesn't sound like you're going to have a very productive negotiation if at least as far as my experience is, that you do have confidential. But if that's up to you, I suppose, Mr. Peterson. You can just say no, thank you.
As a lawyer with a lot of gray hair.
As a lawyer with no hair.
Take
your best shot. Yeah.
Coming up behind you. The settlement is always preferable to litigation, in my view. A client is generally advised, well advised, to see if they can find a meeting ground. I cannot imagine that any lawyer could go into a settlement discussion knowing that any discussion they have of the facts may then be presented, not the fact themselves, but their discussion of the facts is going to wind up being a subject for trial. That can't be done. You cannot talk to people like that.
No, I agree with that, and I think that if you each have these positions, it seems to me, if you insist on settlement negotiation being open.
Yeah, and I'm not saying that.
Okay.
What I'm saying is we don't need you to impose on us a paragraph that later can be parsed, especially this shall be non-discoverable, shall not be disclosed, yada, yada. We don't want to have a parsing later that is unfavorable to us when I think we're grown-ups and we can talk about how settlement discussions are going to be conducted.
Well, based on the respective positions, I have my doubts, but why not? Why not? Well, certainly makes sense to let you try it, and then if you want any help that I may be able to give, I'm happy to try. So at this point, I'll rule that we're not going to adopt anything after this in paragraph 4 after this matter. Period. And then if you're Mr. Peterson, you can just say this isn't working, and I think at that point, when you tell me it's not working, I just probably should have a hearing because I don't know what else is going to work.
Yeah.
That's probably accurate.
Yeah. Anything else?
That's all that I've got.
Well, I have 2 other items. One, if you're setting a hearing date of the 24th, I would like you to establish a date for exchanging witness lists. That'll be, let's say, 7 days before that, so that we both know the witnesses who will be expected to attend the hearing. And, obviously, if there are department witnesses that I would like, I will probably include them on my list. But if Mr. Peterson doesn't include them, then I will certainly subpoena them. The other thing is I'd like the hearing officer to set a date for motions. In particular, we have an organization that is very interested in exploring whether or not they're going to file a motion to submit an amicus brief in this proceeding. And it is the New England Legal Foundation. They're in Boston, and they delve into constitutional cases in all state and federal courts across the country. They're predominantly New England, but they do file amicus in U.S. Supreme Court cases from other jurisdictions. So I would like the hearing officer to set a date for motions with that particular motion in mind. And to that end, I would say, 10 days before the hearing probably makes sense, although now that you have it on a Wednesday, that probably is a weekend.
What's the department's response to that?
A is news to me. That's the first response. Our rule provides for intervention, it doesn't provide for an amicus brief. It doesn't set any dates. It just says it would be made by motion to intervene and so on. The usual standards for intervention are having a stake in the thing.
It seems to me that there's merit to the idea that if we have some deadlines, that the whole process is going to move more efficiently.
That's fine.
Well,
And so what I was thinking, do you think that, it seemed to me, are you going to want to depose any of these witnesses, or you feel like you have, 7 days may not be enough time for a witness list? That's my experience. You're going to have the witness list 7 days before you have the hearing.
I'm not sure that the department's rules contemplate discovery and depositions.
Okay.
So, as unfortunate as that is.
This is something I
that
should,
is just the way it works.
as a new person here, I should have known that. So, okay.
The other thing on intervention, Mr. Peterson's looking at section 6, I believe it is, of the rules, but section 9 deals with motions, and it does not say there's only motions to intervene allowed. It doesn't characterize the types of motions, and I'm reading here today that they have to be filed at least 15 days prior to the hearing. So if we subtract that from the 24th, I would say October 11th for motions appears to be, and then 10 days before or 10 days after any opposition has to be filed.
It seems to me, and I'm happy to go through this with you, but this seems to me that's something that you could work out fairly quickly on your own.
Right, because I immediately see that October 11th, with 10 days to respond, throws our previously talked about briefing schedule into a cocktail.
So what, do you think that the situation is such, this kind of a discovery schedule is something you couldn't agree to?
Yeah, as I say, the notion of an amicus, it came as news to me, so I wasn't contemplating it and thinking dates.
Well, I raised motions with you.
But let's.
Why don't we, if I can?
Yeah, I think you should get together and.
Why don't we submit a proposal, a
Yeah.
joint proposed order to you, based, trying to track the dates that are already set out and the principles in that, and we'll get that to you.
And if I don't, let's leave it. If I don't, I will hear from you.
You will.
Yeah, okay. That seems to be a much better way to do it because, again, you're more familiar with the process works here, both of you, obviously, and you can use your experience to come up with something that will keep this efficient, but still give you a good opportunity to be heard on the issues you need to be heard on.
Yeah, we're going to have to rethink some dates here.
Yeah, I understand. That makes sense too, as well. So what I'd appreciate is to, and I think it's everybody's best interest to get it to it as quickly as possible. So
Oh, sure.
Yeah. When do you think is a reasonable time?
Between reasonable people, a reasonable time.
By the end of the week?
By the end of the
Certainly.
week, yeah.
Maybe even by the end of the day.
That's what I was thinking.
Maybe even by the end of the day.
Maybe by noon.
Maybe even by noon,
Yeah.
yes.
Okay, all right. So I think that would work better than having me try to fumble through some series of dates which I can't anticipate what problems you'd have.
Right.
Anything else?
Not on my list.
I believe that works for me. Thank you.
So the hearing is closed. I'll be waiting for your schedule, and we'll make that an order, and then we'll get rolling.
Right.
Thank you.
Thank you.
Thank you.